dog is on. Okay. Legal issues. This is important. As you all know, I work as an expert witness, and that means I spend a lot of time seeing how IT practitioners, software developers, system administrators, team leaders, managers get involved in litigation. Some of the legal trouble they can get themselves into, both civil and criminal. Now, this is my standard disclaimer slide here. I am not a lawyer. This is not legal advice. I have to tell you that because you get in trouble if you're offering legal advice and you're not a lawyer. These are the cautions, as I said there, that I would give any colleague and frequently do and have over the years. 6 areas, 6, not 5, 6 areas to look out for. Unauthorized access, intellectual property, your own private independent projects, non-compete restrictions, trouble failed projects. Hey, you haven't heard about that before, have you? We'll skip over that slide, or we'll go through it very quickly. And preservation and discovery of files. Unauthorized access. Congress, in its infinite wisdom, and let me just say editorially here, Congress is wretched at technology-based litigation. Any litigation involving information technology that Congress passes is bad. It's just bad. Even if it's well-intentioned, it's bad. Computer Fraud and Abuse Act was passed in 1986. That was a time when there was big concern about hackers and people breaking into systems and so on and so forth. And it basically criminalizes unauthorized and provides for civil penalties as well for unauthorized access to computer systems. The problem is it's been continually expanded in its definition since then, over the last 30+ years. And it's all heavily weighed on the part of the alleged victim. This is important because organizations will go after you. How many know who Aaron Swartz was? He was a believer that information should be free. He was upset that a lot of journal articles were behind paywalls. And so he set up, quite illegally and without authorization, he set up the server and at MIT and used MIT access to download hundreds of journal articles from various academic journals that were behind paywalls and then uploaded them for free on the internet where anyone could read them. The prosecutor who got arrested for this, he was found out, was arrested. The prosecutor was threatening him with 35 years in prison for this, and was able to do that under the statute. Aaron's reaction was to kill himself. The lesson I'm trying to say here is don't go where you're not supposed to. As fun as it may seem, it's kind of like, yeah, I'll poke around, and especially not even in your own company. Don't poke around where you're not supposed to, because if you then leave the company and you don't leave on good terms, the company will come back and say, hey, they were abusing our computer systems. He was doing or she was doing stuff that they weren't supposed to be doing. Be cautious. Don't think nobody's going to find out. I've also had training in computer forensics. You'd be surprised what they can find out. The traces. We live in a. There was a. Let me finish the sentence here. Novel by Alfred Bester came out in the mid-50s called The Demolished Man. Excellent novel, by the way. But it postulated a future society where there were telepaths who could read your thoughts up to a certain extent. And the whole plot is about a man trying to set up a perfect murder under those conditions where the murder takes place but they can't find out from him that he's done this. He has a way of trying to block the telepaths actually reading his mind. We live in a society like that, but with digital traces. I think I've already told, have I told you my Google location tracker story here? I was retained as an expert in a case that had to do with, it was a wrongful termination suit. I was retained by the person who's alleging wrongful termination. And her former employer claimed that she did not show up for work for 2 or 3 days before they fired her. And she said, yes, I did. And she had an Android phone, and she said, I had location services turned on, and you know, it shows, I still have the file on my phone that shows that. So I asked the lawyers, let me see it. Well, it's an XML file pulled off her phone. I said, well, this is nice and it supports her story, but anyone can edit an XML file. They can upload it to phones. There's nothing proof here. I said, you know, I'd like to help you, but really what I would need is something directly from Google that's off their servers and that they certify is correct. And for me, that was the end of the conversation. I didn't think anything would happen. About 3 months later, the lawyers contacted me and said, we have a document to send you from Google. I said, oh, well, let me see it. I got a 65-page document that was her phone's location history over 3 days. Basically every 5 minutes.
From 5 years previously.
Huh?
From 5 years previously.
From 5 years previously. That's terrifying. It's like, you know, there's 2 billion Android devices out there, and Google was able to go back and from 2014 pull out those specific 3 days and show the lat long and estimated accuracy of her location through the whole thing. And I plotted it and said, yeah, this actually matches exactly what she has on her phone. We can show that it's there. And but that was rather chilling. It's staggering the vast amount of data that exists out there, the digital traces that we leave everywhere. Intellectual property issues. 4 areas, and I have acted as an expert witness in all 4 areas. Licensing, paying the right license for anything that you have to license, software, video stuff, games, whatever. Copyright violation, trade secret, theft of trade secret, patent infringement. This is a multi-trillion-dollar industry. This is, everyone's into intellectual property now. And I've watched this over 20 years just absolutely explode. The point is that companies will go after you. And they'll often go after you, not because they think you can pay damages, but as the French saying goes, to encourage the others. Or actually, in this case, to discourage the others. So there are people who have found themselves faced with lawsuits, say, from the record industry of America, with allegations of $100,000 charges for each song downloaded from a website, as far as license violation. So the point here is that be careful what you copy and how. And as far as your company stuff goes, oh, let me tell you this, never walk away with anything. And again, I always have trouble keeping track of what stories I've told you. I think I may have already told you this one. Another case I was on where a group of developers were developing database tools at a company that was getting bought up by a big company. And they all went over to another smaller company. And one of them took along a CD-ROM of all the source code that they'd been developing to date there. And it was 5 of them who went over to the second company, and after a year or 2, one of the 5 didn't get a promotion that he wanted, and he left the company and he wrote an anonymous letter to the first company, the big buying company, and said, oh, by the way, they have your source code over there. And so I got retained by the allegedly infringing company. Said, we have millions of lines of source code. We need to know. And it said, by the way, yes, we found out this one developer did, in fact, have the CD-ROM. We need to know if any of the code on that CD-ROM is in our production code. And it's like a 3 million line set and a 5 million line set of code. So I went out and bought a couple more PCs. I wrote some tools to do fuzzy matching in case they were like modifying or changing stuff, and had this program running on three computers for 10 days. Did 15 trillion line-to-line comparisons. And sure enough, guess what I found? I found a sequence of comments in the SQL parsing code, actually SQL parsing grammar, that were identical in both sets. This one developer had saved himself 2 weeks of work by simply copying the Lex and Yak files for the SQL parser, for this particular version of SQL. And it being very expensive litigation for the company that hired it. Yes, I should be stopping. Questions?
One thing that just comes to my mind, and I've actually thought this multiple times over the course of me running code here at BYU, where we're all required to do the same project and stuff like that. I guess I've kind of come to the conclusion that I would think that it's inevitable that our source code would end up being extremely similar given the limited scope of the projects that we do.
How do you deal with plagiarism?
Well, how do you deal with that? I mean, I would assume that inevitably there are some things that are definitely going to seem the same, I guess is the best way to put it. And if not, I mean, it is pretty easy to just change a couple variable names, but the logic is, like, that's still the right logic for the code, right?
Actually, you touch upon a very good point, because this is an issue in software copyright issues, especially in cases where someone takes an existing set of source code and rewrites it in a different language. And there is an established standard that's called abstraction, filtration, comparison. Abstraction says you look at different levels of abstraction, the overall architecture, the design, specific implementation areas, and so on. You filter out stuff that can be explained away. It's necessary. I mean, if you're doing sorting, you're going to do sorting. If you're using a known sort thing, you can't claim, yes, you use quicksort and I use quicksort, therefore you copied my code. Or you may have code that is mandated by the environment. If I'm interacting with Windows and you're interacting with Windows to accomplish the same thing, our code is going to look very similar. And whatever you're left with after you've filtered out the stuff that can be explained by all that, that's what you compare. And in this particular case, what was significant was it wasn't the code. In fact, the actual Lex and Yak files had been reformatted differently. It was the fact that there were identical comments in the same order.
And that seems obvious.
And there's no, yeah, that's a killer in software copyright cases. When you see identical comments in both sets of code, you know, unless it's something more than 1 or 2 words or something that would be very vague, that's usually a fairly standard thing. But no, it's a good point. Non-work projects. How many of you have software projects you're doing on your own at home? Okay. You go to work for a company. Before you sign anything, accepting a job, you let them know, here are the projects that I'm working on personally. At home. Will this be a problem? If you don't let them know that, what you may find is first that your employment agreement says anything you do on your own hours, they own as well. Second, they may come back and claim, well, you never told us. So we're assuming that somehow, and particularly if it's the same thing. Okay, you know, what you want to do is you want to get an agreement ahead of time saying, yes, I'm working on these projects. This has nothing to do. I will not use any company resources or time to work on these. Because if you do, they'll come after you and say, no, I'm sorry, you did that while we're paying you. You did that on our computers. Even if it's nights and weekends. You just don't do that. So, disclose the projects, have an actual written list that they sign off to saying, yes, we understand you're writing the next great RPG. And yes, we're a database company, and so we agree that this is a separate product, it's not going to be an issue. Again, don't work there using any company equipment, resources, time, and don't walk away with any of their code, materials, or anything else. Any questions here? I'm rushing through this a bit because I know you really want to hear Crystal. She's far more interesting. Non-compete restrictions. How many of you have ever signed a non-compete? Okay. Here's the important thing about non-competes. Their strength and enforcement varies wildly by state. For example, in California, it's almost impossible to enforce a non-compete. That's a deliberate, conscious effort by both the state judiciary and the state legislature. It's one of the reasons why the tech community thrives so much. It means you basically go from Google to Apple or Apple to Google, and unless they can show you're stealing trade secrets, they really can't do much about it. So the first thing is to make sure when you sign any sort of employment agreement, look at the non-compete, see what they're doing, see how specific it is or how general it is. What you don't want to do is say, yeah, this is a 5-year non-compete, generally against anyone we deem a competitor. You say, no, it's 2 years and you need to list the specific companies there. You want to negotiate that down as little as possible. Even if you move to another state, some states will enforce the non-compete from the state you moved out of. Others won't. You always get it in writing, get details in writing. Don't let them say, oh, never, you don't have to worry about this. We never enforce this. No. Trust but verify. Get it in writing. Narrow it down. You ask about using a non-disclosure agreement, which basically says, I won't disclose any proprietary company information. So I can go from Google to Apple and I can't disclose any Google proprietary information, but I have, full freedom to work there. And like I said, if they insist on a non-compete, request or demand an explicit list. Any question? Well, actually, I've got one man. This is how wildly the enforcement varies. The darker the state, the more it's enforced. You see that Oklahoma, North Dakota, and California are pretty good. Utah's not bad. And if you have a non-compete from another state, Utah will only enforce it if it complies with Utah state law. All the dark green ones are basically saying we'll enforce a non-compete from any other state according to that state's laws. Any questions about this? Yes?
What about across country lines?
Cross-country lines are probably generally safe because international law is really tough. Yes?
So it's the state you move to that has all the say on whether it's enforced. So if you get a job in another state that's really strict about enforcing it, but then you move to California, they can't stop you from taking any.
It'll be very hard for them.
Yeah.
The judges would basically probably throw it out and say, I'm sorry, that's not how we do things in California.
Okay.
Yeah. There's a reason why California is a big tech center, yes.
Even knowing that your non-compete couldn't be legally enforced, would it maybe cause employers to hesitate to hire me though, if they knew that they might have to get caught up in that?
It might. They may ask you about non-competes, they may not ask you about non-competes. They may not care, it depends where you're at. In California, like I said, they laugh at non-competes, like, yeah, no big deal. Yes, question?
Yeah, I've heard from, talked to a lawyer before I said from last job, like, judges really don't like non-competes in general.
They don't. They don't. But there are some states, particularly in the Midwest, where they really will enforce them. And I've seen some litigation where people were signed a 5-year non-compete and the company defined it very broadly. Basically, they couldn't find work because why? They were doing, this was their specialty. And suddenly they had a non-compete that wouldn't allow them to earn a living. Trouble failed projects. You guys don't know anything about this. This is pretty much what we've talked about all semester. So the only thing I will say here is, and this is a lesson I learned at Pages, where I learned so much. There were things that were going wrong that seemed obvious to me, and I thought surely everyone else sees them. And then we got into the whole grind of being a year late in shipping, and I realized that no, I need to stand up and wave my hand. And remember that last question on the midterm?
So many red flags.
So many red flags? That is almost verbatim a situation from my first consulting engagement. Seriously. I was brought in to help with the satellite stuff, but they were doing this other project. And quite literally, I mean, I've mentioned this a few times. I showed up at my first meeting and said, okay, this is start of November. We're going to start coding. We get the 1.0 development system, which the developers had like 2 weeks of training on. 1.0 release of an obscure ASN.1 network management programming language. And they literally said, we're going to start coding in January, we're going to go into testing in March, and we're going to ship in April. And they said, who signs up for this? They're going around the table and his hands are going up. They said, no! I said, we don't have an architecture. We don't have requirements. I don't sign up for this. I asked you for 5. I wrote an email with 13 risks that I saw in that situation. And about 8 weeks later, I sent around a second email that showed that 12 of the 13 risks had come to pass. And the project did eventually crater. But that was after they'd let me go as a consultant. Okay, preservation, discovery of files. This is an important issue, and this has become a massive headache for companies involved in litigation. Basically, once there is even the possibility of litigation, you don't even have to have litigation starting, you have to preserve electronic documents. Actually, preserve all documents. But over the last 20 years, there's been this enormous shift to electronic documents. Companies can have petabytes of electronic documents, and they have to sort through them and figure out which ones are we going to produce the other side. This is discovery. I'm back getting ahead of myself. In litigation, whether it's civil or criminal, we have the issue of discovery, which is that each side can request, we want all documents, all information you have on these set of topics involving these peoples, sort. You have these lengthy discovery requests. I read them all the time. Then the other side is responsible for producing everything that matches that. One of my great faiths in the legal system in humanity is that people do this even though they're often incredibly incriminating documents. It's like, yeah, they really produce this. This is so cool because this is exactly what we want. As a software engineer, what I always want are the emails from the engineers on the other side. Because engineers are honest. Especially talking among themselves. This code just sucks. This is so, literally one of my first cases, there was an email. One of the engineers was saying to the other engineers on the other side, I can't believe we're charging the customer $100,000 for this garbage that we're sending them. And the lawyers for the other side tried desperately to keep that out. No, they shouldn't be able to rely on that at trial, and they lost that, and then he settled immediately before the trial started. But you need to preserve documents, and this is even if you have, say, rotating backups. Famous story, fen-phen. I don't know how many of you have ever heard of fen-phen. It's a weight loss drug from about 20 years ago. American Home Products produced it. Turned out that it had health complications. You had a side effect of pulmonary hypertension. And there was this large lawsuit against American Home Products. And it was going into litigation. Well, and again, you're talking mid-90s here, mid to late 90s. The IT systems, American Home Products, were doing tape backups, and they had 4 tapes that they were rotating through for their monthly backups. Guess what? They didn't stop rotating them through. And so they were writing over the historical data that they had, which included their email archives and everything else. And because they failed to preserve those tapes and what was on them, the judge instructed the jury to treat that as a case of spoliation, meaning you may assume that American Home Products deliberately wrote over those to prevent bad information getting to the jury. And American Home Products lost the lawsuit and went bankrupt. So the short answer is, if you're at a company where there's a pending chance of litigation, don't destroy anything. It can actually hurt the company. If your company starts destroying it, that's bad news. That's the Anderson Consulting, or actually Arthur Anderson, did that in the Enron case, and the whole company went out of business. One of the big 6 consulting firms. So, Working in IT, you will spend the rest of your lives dealing with cutting-edge legal issues. Because new things will always come up, constantly, depending on what you do. If you snap photographs of random people, can they come after you and sue you for using their likeness without your permission? Some people have tried to do that. Be wise and cautious, and particularly with regards to your own stuff, get everything in writing. When you're applying a job, don't rely on verbal assertions. Get everything in writing as far as what you can and can't do, what you're working on, so on. Any questions at this point? No? Okay, that's the end of that lecture. I rushed through that, but like I said, I don't need time for Chris. Yeah?
So, say you're interviewing at a place and they want to kind of negotiate about some of these legal things.
Mhm.
How hard do you push on that sort of thing?
How bad do you need the job?
Yeah.
It's like salary.
Yeah.
It's like, and often, and I think Chris will end up talking about this, often it's like, well, I really want this job, so yeah, I'll go ahead and do it.
Yeah.
And then you may find later on, I really wish I hadn't done that. My recommendation is the best negotiation position you can have going in for a job interview is being willing to walk away if you're not happy. Now, there are things you may be willing to trade off. You may be willing to say, yeah, I'll put all my projects on hold for the next X years while I'm working here, and besides, I only plan on working here for a year, then I'll look for a new job. So there's stuff like that, but just like benefits, just like salary, it's this, are you willing to accept what they're going to give you, or are you willing to walk away and go look somewhere else? And that'll depend on what success you've had so far and what interviews you've had. And there are times you take jobs because you want to, and there are times you take jobs when you have to. I've been in both situations. And sometimes when you take jobs and you have to, it's like, oh, I'm doing this, and I'll deal with it for as long as I have to deal with it while I look for something better. Any other questions? Last team status report is due Saturday. Next Monday, less than 2-minute business pitch and your final demos for all the groups. Last Monday will also be the cutoff for all makeup work. So if you've got videos to watch, there's stuff you haven't read, and you can read it the next week, and then send me a text or DM on Slack and say, please, Professor Webster, I read this. All I care about is that you read the stuff, quite frankly. So if you have stuff like that to make up, stay up. These grades are pretty much up to date on Learning Suite. So you've got basically 5 percentage points left, and 4 of those by your team should be automatic, which is 1 point for the status report and 3 points for the demonstration. And then deliverable number 10, which is lessons learned, is in your control, and that's 1%. That's by the last day of class there, 12. And of course, there's no final exam. Ooh, yep, by design. Late midterm and no final exam by design. Most of you should get to A's in this class, quite frankly. This is actually one of the better, I'm trying to think, I'm not sure I've had a class where the grade on the midterm has been as heavily weighted up in the A's as this one. Usually it stretches a bit more into the B's and C's, and here it's like, the diagram on Learning Suite is like, and that's pretty much the whole diagram. So you guys did great on this. Let me take roll real quick, and then we'll turn time over to Crystal.